A federal judge just unsealed 347 pages of documents that Donald Trump fought for 2 years to keep hidden. These aren't routine filings. These are internal financial records and sworn testimony from former executives painting a devastating picture of systematic fraud. When a federal judge overrules every objection from a former president's legal team and orders immediate public release, you know something catastrophic is about to explode. Hit that subscribe button right now because you won't want to miss any of the videos I release. So what triggered this unprecedented move? Judge Miranda Chen found Trump's attorneys provided no legitimate legal basis for secrecy. The documents show inflated asset values, hidden payments, and falsified records presented to banks. This isn't another political controversy. Members of Trump's own business empire are cooperating witnesses. And when a federal judge writes no credible justification for concealment in a public order, something enormous has detonated. Here's what's been unfolding. Tensions between Trump's legal team and prosecutors have been building since March 2023, fueled by sealed grand jury testimony and repeated battles over document production. Everything escalated on January 22nd when Judge Chen signaled she would unseal materials Trump desperately wanted confidential. The order dated January 29th encompasses 3 categories. First, financial statements from 2016 through 2022 showing values prosecutors allege were systematically inflated. Second, internal emails between Trump Organization executives discussing how to present valuations to banks versus tax authorities. Third, sworn testimony from Alan Weisselberg, the organization's former CFO, who entered a cooperation agreement with prosecutors. This wasn't about accounting disagreements. It was about what prosecutors call orchestrated fraud to secure favorable loans while minimizing taxes. Smash that like button if this is making sense so far. When Judge Chen reviewed the sealed materials privately, she recognized immediately that Trump's secrecy arguments couldn't stand. Demands to unseal records involving public figures only succeed when a judge concludes secrecy serves no legitimate purpose and transparency is essential. Here's what sources familiar with proceedings say happened next. On January 23rd, Trump's legal team filed an emergency motion to block unsealing. 9 attorneys representing Trump personally and the Trump Organization appeared before Judge Chen in a closed session that lasted nearly 4 hours. Sources told Reuters that Trump's lead attorney, Clifford Hayes, a former federal prosecutor himself, stated with visible urgency that the documents contained proprietary business methodologies protected as trade secrets. He argued that revealing Trump's valuation strategies would cause irreparable competitive harm. Hayes specifically claimed that forcing disclosure would essentially be handing competitors a roadmap to Trump's business operations built over 5 decades. Assistant U.S. Attorney Rachel Brennan, who has prosecuted white-collar financial crimes for 12 years in the Southern District, countered with devastating precision. She told the court that materials show systematic misrepresentation to financial institutions, which is a federal crime with absolutely no privilege protection under any circumstances. Brennan reportedly stated that trade secret claims cannot shield evidence of fraud and that attorney-client privilege doesn't extend to communications in furtherance of crimes. By January 28th, Judge Chen issued her ruling. The 32-page order systematically dismantled every single argument Trump's team presented. Chen wrote in blunt language that financial records submitted to banks and government agencies cannot claim trade secret protection when they form the factual basis of criminal allegations. She noted that Weisselberg's testimony was given under oath in proceedings where Trump's attorneys were present and had opportunity to cross-examine. Most significantly, she stated the public interest in transparency regarding allegations of bank fraud and tax evasion involving a former president far outweighs any claimed private business concerns. Drop a comment right now if you saw this coming. I read every single one. Now things get explosive. When Judge Chen's order was filed at 4:47 p.m. Eastern on January 29th, reporters immediately recognized the magnitude. It mandated immediate public release. Within 90 minutes, documents appeared on the court's public access system. The bombshell came when analysts read Weisselberg's deposition. The testimony contained specific admissions that Trump personally directed inflation of property values, knew figures were inaccurate, and understood they would secure loans. One passage stood out. When asked if Trump reviewed valuations before submission to Deutsche Bank, Weisselberg testified, "He reviewed every number. He questioned anything that seemed low. He told us the goal was to show strength, and everyone understood what that meant." This sent shockwaves through the legal community and Republican leadership. When a federal judge rejects every concealment argument in language suggesting deliberate obstruction, something profound has shifted. This isn't the first time a president faced document disclosure over financial impropriety. Think back to Richard Nixon and the Saturday Night Massacre of October 1973. When Special Prosecutor Archibald Cox demanded White House tapes, Nixon ordered his firing. The backlash was immediate. Republican senators began signaling his presidency was unsustainable. Within months, facing certain impeachment, Nixon resigned. Then there was Bill Clinton's deposition in the Paula Jones lawsuit in January 1998. Clinton fought to avoid testifying about Monica Lewinsky. When forced to testify, his false statements formed the basis for perjury allegations leading to impeachment. The key difference is Clinton's conduct didn't involve financial crimes. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget Trump's own history. During the Manhattan DA's investigation, Trump's lawyers spent 2 years appealing subpoenas for tax returns all the way to the Supreme Court. They lost every appeal. The documents were produced, leading to criminal charges against the Trump Organization and Weisselberg. Now it's different. The documents include detailed testimony from Trump's most trusted financial executive explicitly implicating Trump in knowing fraud. The pattern is clear. When presidents obstruct disclosure of financial records, courts eventually force transparency. When transparency reveals criminal conduct with insider testimony, legal jeopardy becomes existential. So what allegedly triggered this unprecedented judicial rebuke? According to legal experts who reviewed Judge Chen's ruling and the newly unsealed materials, the documents demonstrate clear violations of federal bank fraud statutes, specifically 18 U.S.C. Section 1344, which prohibits knowingly executing schemes to defraud financial institutions. The financial statements show property valuations submitted to Deutsche Bank that are dramatically inconsistent with values declared to tax authorities for the identical properties in the same tax year. One example is particularly damning. Trump Tower in Manhattan was valued at $527 million in loan applications submitted to Deutsche Bank in 2017, but was simultaneously assessed at just $238 million for New York City property tax purposes that same year. The differential wasn't based on different valuation methodologies or changing market conditions between filings. Internal emails, now part of the public record, show Trump Organization executives discussing in explicit detail how to justify the higher figure to the bank, despite knowing it exceeded any reasonable professional appraisal by more than double. One email from a senior vice president states, "We need creative language for DB meeting tomorrow. They're questioning the 527 number. Boss wants it higher, not lower, so we need to make it work." Here's the kicker that demolishes any claim of innocent error. Weisselberg's sworn testimony includes his direct statement that Trump personally reviewed and approved both sets of figures. Weisselberg testified that Trump specifically instructed staff to use whichever valuation number benefited the organization in each particular context, whether seeking loans or minimizing tax obligations. This wasn't a good faith policy debate about legitimate valuation differences or acceptable ranges. It was what prosecutors characterize as the deliberate submission of false financial information knowingly and intentionally designed to secure hundreds of millions of dollars in favorable loan terms while simultaneously reducing tax payments. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone. This isn't just about whether one businessman committed fraud. If a former president can systematically provide false information to banks, avoid disclosure through legal obstruction, and face no criminal consequence, it establishes that financial fraud carries no real penalty for the politically powerful. Once that precedent is set, rule of law becomes meaningless. This puts Trump's legal team in an impossible position. On one side, they face pressure to continue fighting. That means arguing business valuation is subjective, charges are politically motivated, and Trump had every right to present properties favorably. It means characterizing Weisselberg as a disgruntled employee seeking leniency. On the other side, they must reckon with documents showing their client's CFO testifying under oath that Trump knowingly submitted false information. They must explain why a 30-year financial executive would fabricate testimony, risk perjury, and provide prosecutors with supporting documents. And here's the tricky part. There's no credible defense. Either Weisselberg committed perjury, requiring evidence prosecutors would have discovered, or intentionally inflating asset values isn't fraud, which contradicts federal law. Legal and political analysts are calling this a genuine turning point in Trump's mounting legal exposure. Jennifer Taub, a George Washington University law professor and former securities fraud prosecutor with the Securities and Exchange Commission, told MSNBC in a detailed analysis that the unsealed documents provide prosecutors with precisely what they need to prove criminal intent beyond a reasonable doubt. She explained that bank fraud cases typically fail at trial when prosecutors cannot demonstrate that defendants personally knew their statements were materially false at the time they made them. Weisselberg's testimony, combined with internal communications discussing valuation strategies and Trump's personal approval, completely eliminates that defense. A former federal prosecutor from the Southern District of New York, who spoke on condition of anonymity due to ongoing cases, added that these materials substantially increase the likelihood of additional cooperation agreements from other Trump Organization executives who participated in preparing these documents. He emphasized that mid-level employees who worked on financial statements now face a stark choice: cooperate with prosecutors and potentially receive immunity, or remain silent and risk becoming defendants themselves when Weisselberg's testimony directly implicates their involvement in what prosecutors allege was a conspiracy to defraud. Do me a favor and slam that like button, because it genuinely helps this video reach more people. Even Jonathan Turley, a George Washington University law professor who frequently defends Trump in media appearances and testified during Trump's first impeachment, acknowledged that the newly public materials present serious and undeniable legal problems. He told Fox News that while Trump could theoretically argue he relied on subordinates for accuracy and didn't personally verify every number, Weisselberg's testimony describing Trump's direct personal involvement in reviewing and approving inflated valuations fundamentally undercuts that defense before it can even be presented. So let's break down what this unsealing means across multiple dimensions. First, the immediate legal impact is substantial and possibly irreversible. Federal prosecutors in the Southern District of New York, one of the most sophisticated and aggressive financial crimes units in the entire country, now have publicly available evidence supporting potential bank fraud charges. That means any subsequent indictment would reference materials already part of the permanent public court record, making it virtually impossible for Trump to claim the prosecution is based on secret evidence or manufactured testimony. It also means potential jurors will have been exposed to the basic allegations and documentary evidence before any trial begins, fundamentally shaping public opinion in ways that complicate fair jury selection. Second, it creates enormous and arguably insurmountable political problems for Trump as he actively campaigns for the presidency. Every single Republican primary debate and general election forum will inevitably feature questions about why his own CFO of 30 years testified under oath that he committed systematic bank fraud. Campaign opponents will quote directly from Weisselberg's deposition transcript in television ads and debate exchanges. Third, and perhaps most immediately consequential, this disclosure affects Trump's business empire directly and severely. Banks reviewing existing loan agreements can now point to public documentary evidence that prior financial statements were allegedly fraudulent, providing clear contractual grounds to demand immediate full repayment or impose penalty interest rates. Insurance companies can argue policies were obtained through misrepresentation. The financial pressure compounds as legal exposure grows. Drop a comment with your thoughts. I'm genuinely curious to see your perspective. But beyond immediate consequences, this is about whether our system maintains accountability for fraud. If a former president can systematically defraud financial institutions, use every maneuver to conceal evidence, and face no consequence simply because of political status, then rule of law ceases to have meaning. Reports indicate Trump's advisors held emergency conference calls on January 30th. Some argued for appealing to the Second Circuit despite Chen's rejection of their arguments. Others insisted fighting transparency confirms guilt. The campaign team is fracturing between loyalty and recognition that defending indefensible conduct destroys credibility. Meanwhile, core supporters reacted with fury. Social media exploded with claims Chen is a Democratic activist, Weisselberg was coerced, and the prosecution represents deep state persecution. To the base, this confirms the establishment will use any means to prevent Trump's return. Things escalated when Trump responded via Truth Social on January 30th. He called Chen a radical activist judge and claimed unsealing was illegal. He posted Weisselberg was threatened and forced to lie, and real estate values are opinions. He attacked Republicans questioning his conduct, posting rhinos who believe these hoaxes are worse than Democrats, and warned everyone will remember who stood strong. Stay with me. What comes next will completely change how you view this. Here's what makes Trump's response even more damaging. Rather than addressing specific allegations, the reaction was pure deflection. When your only defense is claiming your CFO of 30 years was coerced without providing evidence, you've conceded you have no substantive defense. Legal experts flagged the problem. Former prosecutor Eli Honig told CNN Trump's post could be introduced as consciousness of guilt. When defendants attack witnesses and judges rather than presenting evidence, prosecutors argue that demonstrates guilt. This goes beyond one unsealing order. It's about whether we maintain a system where defrauding banks carries consequences regardless of political power. If former presidents can commit financial fraud and avoid prosecution because accountability is deemed politically disruptive, we've established a two-tier system exempting the powerful. It's about whether the presidency confers permanent immunity from prosecution for crimes committed before office. If this blows your mind, hit that like button right now. Here's the situation. A judge unsealed 347 pages showing systematic bank fraud. Trump's CFO testified Trump personally directed submission of inflated valuations knowing they were false. This is no longer partisan dispute over business practices. It's about whether documented fraud will result in charges. When judges use language suggesting obstruction and witnesses provide detailed testimony implicating a former president, we've entered territory where accountability may become unavoidable. If there are no charges, it establishes that fraud is effectively legal for anyone achieving political prominence. Keep a close eye. Prosecutors are reportedly discussing cooperation agreements with additional executives now that Weisselberg's testimony is public. Trump's team is preparing appeals, though experts say efforts face insurmountable obstacles. And every bank that lent to Trump is reviewing files to determine if they were defrauded. Before we go further, smash that subscribe button. Here's where things stand. 347 pages Trump fought to keep secret are now public. His CFO testified under oath Trump knowingly submitted false information. Prosecutors now have documentary evidence and insider testimony supporting bank fraud charges. Trump's only response has been attacking the judge, claiming his CFO was coerced and promising revenge if he returns to power. This isn't just another news cycle. This is potential criminal prosecution unfolding in real time. What happens next could determine whether we maintain a system where bank fraud carries consequences or whether the presidency confers immunity. The evidence is public. The testimony is on record. Now we wait to see if prosecutors bring charges, and if they do, whether any jury will hold a former president accountable for what his own executive describes as deliberate fraud. The stakes have never been higher. The documentary evidence has never been more specific. And the question of whether equal justice under law has practical meaning for the politically powerful has never been more immediate. Pause for a second and hit that like button if you're finding value in this coverage.